The case for oral argument this morning, State versus Murdaugh. I believe the clerk of court, Ms. Howard, has already instructed to turn off your cell phones. If you have not, please do so. The courts in South Carolina are open, and we appreciate those who are present and here to observe, not participate. For those present who are not arguing in this case, please do not disrupt the proceedings. Any outburst or disruption will result in sanctions for contempt of court. As we proceed with the argument, just want to notify counsel that on the primary argument, as you begin your 20-minute allotment, 5 minutes will be given without court interruption. So you'll have 5 minutes before we jump in with questions.
It's gonna be tough, Chief.
And we'll have to show some restraint to do that. At the end of the first issue on the post-trial motion for a new trial based on alleged misconduct of the clerk of court, and before we get to the underlying trial evidentiary challenges in that matter, we will take a short break. And I believe, Mr. Harpootlian, you're going to handle the first issue?
Yes, Your Honor.
We're ready to proceed.
Please record, Your Honor.
Yes, sir. Good morning.
Good morning, and as I understand your instructions, I get 5 minutes without being interrupted?
That's right.
Wow. Well, first of all, I want to thank the court for, I know what has been a very diligent effort to wade through this record, a 6-week trial, and then a post-trial hearing that went a few days with additional, 2 hearings, I think, with additional record. So this is not a simple matter. But before I get to that, I want to just remark on this. As I came into this courtroom this morning, I'm reminded that half a century ago, I sat right about there as Chief Justice Woodrow Lewis had us stand and hold our hands up to be sworn in as new members of the bar. All of us could fit in this room. That's how long ago that was. But one of the things that impressed me that day was the oath, and part of that oath was that we swore to uphold the Constitution. And as I stand here today, I'm honored to be arguing about how to interpret that Constitution, the Sixth Amendment specifically. And in my opinion, I would suggest the Sixth Amendment may be the most important amendment because the First Amendment, which gives you the right to speak without government interference, or the Second Amendment, which gives you the right to carry a weapon or have a weapon without government interference, mean nothing without the right to a fair trial and a fair jury. So this matter we're discussing this morning, a fair trial, a jury not poisoned by outside influences, I would submit to you is 51 years ago, as I stood there, I did not realize what I was swearing to do, but I do today. And that is to defend Alex-Murdaugh's right to a fair trial. And I've got to admit, in the 51 years since then, I've never seen a factual pattern like this, where the clerk of court, sets out to influence the verdict, to get a guilty verdict for financial gain. Now, I do want to go to the record fairly quickly and summarize it so that there's no misunderstandings. Rhonda McElveen, who's the Barnwell clerk of court, was asked by Becky Hill, the Colleton clerk of court, to assist her during the Murdaugh trial. She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book because she needed a lake house. A guilty verdict would sell more books. That was said before December of 22. We didn't pick a jury until January of 23. The best way to sell books was a guilty verdict. A guilty verdict would be better for the sale of books. So she explained she had a financial incentive for a guilty verdict. She also made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements. Identical to the statements that I'm going to read you in just a moment by the jurors as they were questioned. Juror P, on the day Mr. Murdaugh was taking the stand, Becky Hill made a comment, watch his body language. Juror X, prior to Mr. Murdaugh's testimony, Juror X heard Becky Hill say words to the effect of, looks like the defendant's going to testify. This is an important day. This is an epic day. It's rare for a defendant to testify. Juror Z, watch his actions, watch him closely. In addition to that, Juror Z said in an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's lawyers, attorneys, which she understood to mean Mr. Murdaugh would lie when he testified, and that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately before he testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741. Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told Juror 741 Murdaugh was going to testify before he testified. That's what the jurors said under oath. That's what the Clerk of Court of Barnwell County said under oath. Judge Toll, from the bench, said at the conclusion of the hearing, asked the question, did Clerk of Court Hill make comments to any juror which expressed her opinion as to what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed it as early as November 22, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified. She made some of those comments before he testified to at least one and maybe more jurors. The Clerk of Court allowed public attention of the moment to overcome her duty.
Can we consider the egg juror's affidavit?
I'd like you to.
Well, in the record, of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's
Correct.
what her stated reason for was during the hearing. What was the rationale for her not allowing the egg juror to testify?
I don't know. Because as you point out, if Juror 741 was to impeach Becky Hill's credibility, now, of course, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question is this, and I'm sure Mr. Waters will cover this. If the egg juror's testimony was just as theoretically impeaching as Juror 70 or the alternate juror's testimony, 741, why wasn't the egg juror allowed to testify?
And I'm not sure that she stated a coherent reason other than she wasn't going to. Remember now.
But she said, her affidavit is in the record, so we know what she said, Ms. Hill said,
Right.
and we now know what Ms. Hill said she didn't say.
Yes.
So I take that to mean that it was considered. The egg juror's affidavit was considered by the court, and we can consider it.
In our defense, when you look at the record, remember, we were starting off with no one was going to examine anyone under Judge Toll's initial order. And then it was a moving target. Then it was going to be some that were going to be examined. We weren't going to be allowed to examine. Then we were allowed to examine. So it was an evolving process. If she, in fact, considered the egg lady's affidavit, she did not cite it in her order, just as she did not cite Juror Z or 741's statements about do not be fooled, comments about how the attorneys are going to try to deceive you.
The state argues in its brief that Judge Toll, in making specific findings as to certain things jurors did say, was an implicit rejection of the other statements the jurors said Ms. Hill made. What's your response to that?
Well, I would say that's wholly unsupported by the record. I mean, a judge in an order is going to say what they considered, and they should say what they didn't consider and why. This implicitly, I mean, the statements by 741, by Juror Z, and by the egg lady, all had bearing on Clerk Hill's credibility and what happened. It's critical. And let me say this also. Even if you didn't have what they said, if a judge, as the jury came in on the day Mr. Murdaugh was going to testify, said, it's an important day, it's an epic day, you better watch how he testifies, and doesn't say that about any other witness, except some sort of charge at the end of the case, or maybe before, but specifically points that out?
Mr. Harpootlian, let me ask you this. Judge Toll placed the burden on your client to prove prejudice in this case. Does Green establish, in a case with external influence on a jury, a different standard and burden of proof than Rimmer and the Fourth Circuit jurisprudence?
No, it does not. It's consistent with Rimmer. All Green says is, we're not going to go through this burden shifting or any of this until we determine whether the statement was inconsequential. I say inconsequential or consequential. And if it is inconsequential, we're not going to go through this analysis. That's all it said. And I'd point out in Green, the process used by Judge Toll of calling all the witnesses up and asking them if it had any influence. Judge Hill, in a footnote in the Court of Appeals Green decision, points out that 606B, he says it's not raised in this case, but, should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So,
that's an interesting point, because Rule 606B says that you can't consider the effect of something on jurors, because otherwise you're invading
yes, sir.
the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladden, where a deputy says he's an evil fellow and, he's guilty.
Right.
They say, you can't rebut that. That's not rebuttable.